as I was mentioning in the last session, that trademark rights are territorial in nature and may be registered. So, the first thing we have to understand that every jurisdiction has its own IP laws. We will have to practice and register those IP rights in accordance with the local laws in each jurisdiction. Suppose there are 100, 200 countries, then you need to have protection in those 200 countries. For trademarks, there are three ways. One is that National Trademark Office, you go to each jurisdiction, file your trademark application, register them. So, that is going to each country and register your trademarks, protect your trademarks. The second is Regional Trademark Office of some jurisdiction. Like in there can be a system where the group of countries, say in European Union, there are 27 countries. They came together, they thought of this idea that we should have one unitary registration, which means that when someone wants to go to Europe and wants to have their own business, then they can straight away go to the European Trademark Office and file one application which would cover 27 jurisdiction. So, that is called Regional Trademark Office of some jurisdiction. There is another one in African Union. There are 16 countries which are under one umbrella. If you go to them, basically those are all French nation speaking countries, French speaking countries. So, you go to them, you file one application and you can have one trademark registration in those 16, 17 countries. And third one is Madrid system of international registration. So, this is called the international registration. Right now, there are around 105 or 6 countries which are member of Madrid Protocol. What happens? India joined the Madrid Protocol in 2013. This is a system administered by World Intellectual Property Organization. So, these are three ways of registering your trademarks. For regional trademark, like in African Union, there are 17. The 17 for each jurisdiction they can be different. So, right now there are already 3 regional trademark system. One is European Union, one is ARIPO, and one is OAPI. So, those 2 are under African countries and one is under the European Union. Madrid system of international protection, this is international registration. International registration, it has covered the maximum number of countries, around 107 members are currently there. So, rights are obtained by registration or by use. So, trademark rights, they are obtained by registration in each jurisdiction or through use. Through use means through the common law rights. Common law rights means through, like I was mentioning earlier, that the common law rights means that the rights which has been acquired through use of that trademark. Even if you do not register it, then also you have a right. Like you know, in ICAR, they have applied for PUSA trademark in 2013, but they have been using it since 1907. That does not and their application is still pending, which means that they have a right under common law, even if they have not got the registration, but their rights are originating from the use, that is from 1907. So, but there are only few countries where such rights are available. They are basically under the Queen's, those countries, Commonwealth countries, you can have the common law rights, but there are some civil countries like China, you will not have the common law rights there. You need to register your trademark. You can't say in China or in UAE that you have been using this mark say for the last 15 years and I have gained sufficient reputation in the market. So, I should be the exclusive one. That argument will not be applicable in UAE or China or any other civil based countries. So, protecting a trademark through registration. So, the process is like this. You need to file an application. You need to know the classes in which you use or intend to use your trademark. Classes means that the class 1 to 34 have covered all the goods in the world, and from class 35 to 45 the services have been mentioned. I need to show you the Locarno classification. I think I'll just wait for someone to come and I'll show you that. The most widely used classification system, Nice Agreement, they have 34 classes for goods and 11 for services. You talk about any product in the world, that product will be classified from class 1 to 34, and you talk about any services, that would be classified from class 35 to 45. Some trademark offices such as in US and Canada require the proof that trademark is used. Like in India, we have a system. Suppose if you want to launch a product with a name called any with your name in future. So you can apply your trademark on the basis saying that I'll intend to use this trademark in future. So that is application on intent to use basis. And some jurisdiction they want, and it can be registered without the use itself, without you using your brand in the market. You can have a monopoly, you can have your registration that for that trademark. But like in US and Canada, they need before registration that your brand should be used in the market. Your trademark should be used in the market before they grant you registration. A substantive examination may be required to avoid conflict with an existing and similar mark previously registered. You need to conduct a search before filing an application, so that your application is not refused on the grounds of similar or prior marks. Some countries publish the trademark in a journal allowing third parties to make an opposition. In case they don't find, in case any trademark office doesn't find your application objectionable, it can be accepted and advertised in trademark journal for opposition purposes. So that any third person who has a problem with your trademark, who has a similar kind of mark, he can file an opposition. Once it is decided that there are no grounds for refusal, a certificate is issued within a validity of 10 years. Once there is no opposition, you would be given a certificate which would be valid for 10 years. You can renew your trademark in every 10 years, but may be cancelled. So there is it can't be the case that you have a trademark registration and you won't use it. You need to use your trademark before. Otherwise, what will happen, that your trademark will be liable to be cancelled on the ground of non-use. If the mark has not been used for the say 5 years from the date of registration, your trademark would be cancelled by the trademark. But if someone files a rectification, like suppose take an example where you have say trademark Bata registered for, because Bata is a company who is into shoe business. But if they register it for say computer, and they can register it because no one else is using Bata for computer. But what will happen if they don't use it for computers? For say the trademark office, any third person who has a bona fide intention to use that trademark for computers, he won't be able to use it because the Bata has registration for computer. But if they don't use it, Bata, if they don't use it for 5 years, then the person who has a valid interest in using Bata trademark for computers, he can file a rectification on the grounds of non-use, which means that if you are not using, if Bata is not using, why should they enjoy the monopoly over their registration? It should be cancelled because of the non-use. So registration is doesn't have a life, but it can be revoked, it can be cancelled if the registered proprietor won't use it for some period of time.
Just wanted to know latest this Indigo thing which has come up in the newspaper. Tata has gone against the basically airline. both were in use now. Is it a valid reason? Now raising it at very late stage.
Yeah, it was there in I think two days. I think 2 days before. Yeah. So the issue in that case, I'm not the lawyer involved in that case, but what was published that in 2005, when Indigo, that airplane, when they launched their airline, uh, the Tata had sent them a legal notice saying that you have infringed my trademark rights. Now, why they have taken action after say after almost 7-8 years, the maybe because Tata, there should be a business interest. Business interest means like now Tata has tied up with some other Singapore. So they of course Indigo is #1 airline. So they just want to break this news in the media so that their reputation should be harmed, because if someone claims that you have copied mine, like you have talked about this thing, there are a lot of other person who has said that okay, maybe the Indigo company, they are thief, because ultimately at the end of the day, what is trademark? It's an IP. IP is almost equivalent to your own property. Suppose take an example of you have a land of say 100 hectare, and only one portion of that land is occupied by third person, and it's your wish, you want to take action against that person or not. You can call police and ask them to leave. You will say that okay, I have so much land. There is another alternative. You have so much land that you won't bother for say minute portion of that land. But when that minute portion of the infringer who will try to capture the 50% of your land, then of course you will have problem. So same goes with the Tata. I don't have the thorough knowledge, but I'm just guessing that what could have happened. Indigo, they are the #1 in airline business right now as far as the domestic air industry is concerned. Now Tata has launched its Tata has tied up with other airline, and they see that there is a threat involved. There is already a very good businessman doing his business. So they want to disturb their business. I don't know. Maybe that's the way, or there could be other way also. Maybe the case has been pending for the last 7-8 years. Nobody talked about that thing. I'm not sure, because it's just a business tactic, So let's okay. Yeah, no. इसमें इंटरनेट चलेगा? नहीं? Actually, वो मुझे कुछ दिखाना था. Okay, so what is Madrid Protocol? Is an international treaty. Madrid Protocol, emphasis on Madrid Protocol because India is part of Madrid Protocol. The other two portions like European Union and the African Union, the regional trademark system. National Trademark Office, the India jurisdiction I have already covered in my previous session. So what is Madrid Protocol? Is an international treaty administered by World Intellectual Property Office. It's a simple way to obtain and maintain registration of trademarks in multiple jurisdictions through a single trademark office. Suppose if you want to, if any Indian company wants to launch and register their trademark in those 101 countries, it can be done sitting here in India, sitting here in this office. You can go online, you can file your application, and you need to pay the nominal charge of 2,000 rupees to Indian Trademark Office, and the Indian Trademark Office will send your application to the WIPO, and WIPO will send your application to all those 102 countries. You have an option. Suppose there are 110 countries and you want to protect your trademark in say 5 countries, you have an option of that too. You can select that okay, I am not interested in all those 110 countries, I am interested in only 5 countries, I should be given registration for those 5 countries only. You have an option, because every country has its own fee also involved. So, there is another fee system. Minimum is 100 Swiss franc for each country, and maximum for, it depends. Some countries they ask for 300 Swiss francs, some countries ask for 100. So,
The tenure varies?
Yeah.
The protection tenure?
10 years from the date.
10 years standard.
Yeah, 10 years standard.
Where is this located, sir? This Madrid?
Actually, the World Intellectual Property Organization, I think it's in Geneva.
Geneva.
Yeah, Switzerland. And where is it? If you, yes. So how the trend of registration and the registrant, the number of right holders in 2008 have been increased to, you'll show the rise in the graph, means active registration and the number of right holders. People all over the world, they have been using this system, and it has been increasing in numbers. I'll show you, the next slide is, so how the distribution of registration is important. There are some side effects, or there are some negative points about Madrid Protocol also. We'll talk about later, but how the trademark in the Madrid system is used by a number of users all over the world will show that the companies or the applicants or the registrant who had 1 or 2 trademarks, they have taken the advantage of Madrid Protocol maximum. 79% of the registrant had 1 or 2 registration, which means that the small scale industries, the medium scale industries, they have been very regularly using this system. There are some, that's why I was saying that there are some disadvantages as well. Because of the cost factors, the companies who are small, the companies who have say 1 or 2 brands, they go for what do you call that, the Madrid registration. The examples are, there are a lot of companies, lot of businesses who have 1 or 2 trademarks. If we talk about say food industry, Haldiram has only 1 trademark. Haldiram, you won't know anything else from Haldiram apart from Haldiram. The food industry is one of the example. Other can be some spices which is coming from like MDH has only 1 trademark. So those companies they don't want to spend so much money on going and launching different brands, different products. So they just, if they have 1 or 2 brand, they will just go and file the Madrid application. But there is another way of looking at it. Take an example of Nestle. They have say 50 brands. They have different categories. So what will they do? Maybe they won't go to Madrid protection. They will go and file the international application. Ultimately, it also depends upon the kind of budget you have. So only the 11 and the above percent, like the red portion, if you'll see, only the 4% of the registrant or the companies have taken the advantage of Madrid Protocol who have 10 or who have 11 or above trademarks. Most of the applications were filed by individuals, by the companies who have 1 or 2 trademarks. So who may use the Madrid Protocol? Any person who is a citizen or is a domicile in India, has a real and effective industrial or commercial establishment in a contracting party, or is a national of a state member of contracting organization. The first one is like anyone, the companies who are doing business in India also can file an application. Who is a citizen actually is doing its business in India, they can file application under Madrid Protocol. Third point is a national or a state member of contracting organization, means like in European Union, members of the European Union, they can file applications under the Madrid Protocol. So why this Madrid system is cost effective? Because under the old system of individual, like any company who wants to protect their trademarks in 5-6 countries, I have the France, Germany, Spain, Netherlands and Hungary. So that's the official fee one has to pay, and that's the professional fee of the lawyers or the agents who would be filing those applications. So the total would come around $4,361. While in under the mandate system, that's just a hypothetical figure of the professional fee, and the official fee, if you'll see the difference, the 732 is the one time official fee which you have to pay, and after that the 107 is the constant figure for all the jurisdiction. Even if you include the professional fee which is at the higher side here, the total would come around 2292. I think it's a USDS. So save, that means you would be saving 48% money. Yeah. Yeah, they are all in dollars. So under the old system, because before 2013, most of the Indian companies, they were paying a lot while protecting their brands outside. But after the mandate system came into picture, they have been paying less, and they have been on the same day. There was another article on the Tata news on the at the back side of the, I think on the same page or something in Business Times, where the people have talked about the effectiveness of the Madrid protocol. Only around 250 companies till date have gone and filed their application, because in India, most of the Indian companies also, they are not aware of the Madrid protocol. There have been a lot of seminars, conferences, but people are not aware. So they were still filing under the old system of individuals going to individual country and protecting their trademark. So what are the benefits of Madrid system? It's a cost effective, and that's the best thing. Filing in one office for several jurisdictions, you don't have to engage say 50 lawyers for 50 countries. You can file one application and it would cover all the countries. Use of one language, one is English, and you have to select one more, I think French and Spanish, either of you can select while filing an application. Fees to be paid in uniform currency. You don't have to pay fee, say if you will go to US, you will pay in US dollars. You will go to Australia, you will pay in Australian dollars. You will go to Singapore, you will pay in Singapore dollars. But under the Madrid system, only the Swiss franc is applicable. You need to pay the official fee in Swiss franc. Single international registration covering the designated countries. You will have one single registration number for all of your countries. You don't have to renew all the trademarks in all the jurisdiction. There has to be one renewal fee, one renewal across all jurisdiction. You don't have to pay the official fee for all the jurisdiction. One time of recordal of change for all jurisdiction. That's not the problem. So what is the problem with Madrid protocol? There is one. How can one file a Madrid application? You need to have the basic application or basic registration, which means that Indian applicant needs to have the Indian registration or Indian application, which means they should have one Indian application filed for the same mark for the same classes. After you file the Indian application, then you can go abroad, then you can have the international application. What would happen that suppose you file an application today in India and you file it for the international application as well. The faith of your international application will depend upon the faith of your Indian application for the 5 years from the date of filing of Indian application, which means that if something happens to your Indian application, if it gets refused by the Indian Trademark Office, your international application will become abandoned. It would not sustain in the eyes of law. It needs, because that's a problem with. So when you go and protect your trademark, you need to be sure that your Indian application will sail through. Otherwise, your all international application will will become abandoned.
Is there a definite timeline that after filing some application in Indian trademark office, I have to go then to Martin protocol?
No, there's no time
After
period.
getting the trademark, one can do.
Yeah. You file it today, you can file it the international application tomorrow. So
And even 10 years after?
yeah, 10 years after.
But it is always advisable to have first Indian registration.
Yeah. The problem with then because the chances of getting your international application refused or cancelled, because it will, the faith of your the international application depends upon the faith of your Indian application or registration. Even if your registration, suppose if someone files in cancellation and the cancellation action decided against you, then your international application will also be cancelled. So the 5 years period is the time limit. In 5 years, if nothing happens to your international registration, Indian application or Indian registration, your international application will become independent of Indian application. So that's a problem with the main problem with it's the dependency period. The second is requirement for assistance of local agent if objection arises during prosecution. Suppose if there is any you don't know in third parties whether there are already similar companies who are doing business for the similar brand, so they can raise an objection, or the degree of the distinctiveness also varies. Suppose in India, if a trademark is not say strong, but in some jurisdiction they can think that okay, they are not so strong. It happens. Like one example was cigara. Like when I talk about cigara in India, it may mean, people may think that I'm talking about cigar, but in Turkey, cigara means cigarette. So you can't have a monopoly. Like in their local language, cigara means cigarette. Like in India, cigara doesn't mean anything. If one thinks of, then maybe one can think that cigar, it may refer to some cigar thing, but it doesn't have any direct reference. But in Turkey, there's a direct reference. We have got one trademark refused by the local office on this ground. So how to overcome such kind of things? Like if you file in jurisdiction where you are not sure whether there is any other company who is using the similar trademark, you do the Google search, but even in the Google search, sometimes when you file an intent to use application, it doesn't come on the Google search. So these are the two links where you can do these searches. I wanted to show, can it be online? ही जाएगा ये? इंटरनेट है इसमें? जो दूसरा था वो देखो, ये वाला। चल गया। Next slide. इस पे click करें। चल नहीं रहा। उस पे जाएंगे, इंटरनेट खोलेंगे, वो गूगल क्रोम खोलिए। कनेक्टेड है, इसको पर ये दिखेगी। So searching is very important for any company, for any business. So there are 2-3 searches I'll show you. I think connection is नहीं चलेगा नेट। अच्छा, ओके, वो फिर आप उसी में आ जाइए। So there is a search procedure in ipindia.nic.in. The back for that was for Indian trademark, and for US, for European Union and other countries, there are around for US tmsearch.uspto. You need to fill in the trademark, the relevant classes for the goods which you are going to use, and the European Union. This tm.tn.org, this covers number of countries. Like that search will cover the Austria, Bulgaria, Benelux, these number of they may have their own IP websites, the government website, but this is free of cost, and you can have the first conflict check can be done here. The internet is not working here, otherwise I could. So there, the basic things under the trademarks is when you go for the trademark protection is that you have to consider the time it takes to register a trademark. In India, if there is no objection, then you can have a trademark registered in say 12 to 18 months time. If there is an objection by the trademark office, then it may go up to 3 to 4 months, 3 to 4 years. And if there is a opposition by third party, then it can take say 5 to 6 years. The cost that's because of the huge backlog at the Indian Trademark Office, that's a process which we are following right now, but maybe in future the time period will come down. The cost associated with the trademark protection, there is cost involved while registering your trademarks. When we talk about the National Trademark Office, if one takes the route of National Trademark Office, you have to go to the each jurisdiction. Means that at least you need to send an email to the local lawyers there that we need a registration, and this would be my trademark for this goods, and all those things will happen. You need to pay a certain official fee, the local attorney's fee, that the cost would be associated. In the Madrid, you have to pay one fee, but if there is any office action or there is a office objection by the local trademark office, means the countries where you have designated your application, there would be cost involved. The need for trademark search, it's important. Important to have a trademark search before filing any new application. Like today, if Haldiram wants to go and protect their trademark, they have been doing business for I think 30-40 countries now, but they can't do the trademark search. They can't just stop their business just because the trademark is not available in that country. They will look for the other alternatives. Other alternative means the legal remedies which are available to them. If there is already a person who is using this Haldiram trademark, maybe that person has gone from India and filed a bad faith application, doing a business under the name which has been copied from the main Haldiram. So trademark agent, the lawyers can be required in case of any office action. So if your business is abroad, there are a lot of businesses who does only the export businesses. They only export products. They manufacture it, like in China, they have the Chinese, they manufacture a lot, and there are hundreds of companies, actually I should say thousands of companies who are only into manufacturing and exporting. So they may not have a need to protect their trademark. If the trademark is like in India, I know a lot of my clients, they go to China and get the manufactured product at the and the branding is also done at the China, not here in India. So the final product is here. It comes from China, and the clients, the Indian companies, they sell it in India. So renewing your trademark registration is important, and every 10 years it needs to be renewed. Yes. Yes. Yes.
Let's take a case like in country A, there is a trademark which is in use for last 10 years. That's a registered trademark. Now from a country B, the same trademark, whatever be it a logo or be it something else, the same trademark is used by another company, and they are taking the Madrid Protocol rules where A and B, both the countries are member of Madrid Protocol. Now, based on now, let's say they are using it for 5 years, per se. If they are going to country B for a trademark protection, will there be any possibility that they are getting a registration?
No, because in both the countries, both the companies are using their trademarks.
Right.
They both have the rights. That's a question which you have to consider here, is whether those countries are civil based countries or common law countries. Let's assume it's a common law country. We'll assume either ways. Let's take it the common law country like India and Australia. Okay, both follow the process of first to use. One company is using for 10 years, other company is also using 10 years. And trademark rights are territorial. You can't have a trademark until unless the transborder reputation comes into picture. So transborder reputation is a concept where the reputation of a product which is sold in one country goes to the another country. The reputation of that product also goes to the another country. So that is called the transborder reputation. If that is not the case, then both the companies, they are equally right holders of their respective trademarks. If one company goes to the other country and files a Madrid application or any national application, then their application would be, if they object, the other company who is already selling that brand in that country, if they object, of course they will succeed. Same goes vice versa. So at the end of the day, we have to understand that the rights are territorial in nature. So and that's why I'm saying that maybe Microsoft has gone ahead and said, they out of 200 countries, they have they have been using and gained protection also, say 190 countries. There are still 10 countries left. Let's take a hypothetical question. So those 10 countries, if some other company is using Microsoft trademark, because the original Microsoft has not applied or registered or used their trademark in India, the other person won't be able to register it if the Microsoft objects it, because of its well-known thing, because of the transborder reputation. So that's the concept. If two companies who are, that's the problem with the trademark law, that what is the degree of recognition you seek. Whether I'm talking about the biggest brand, Microsoft, but if there are two companies who are doing the same business under a brand who are, well-to-do marks, but they are not so well known, they are not, people don't know them, that doesn't mean that that both one can claim transporter reputation and one cannot. Maybe only the point is the relevant section of the people. They should know, if your business is, say, for fabric business, if one company is selling it for the fabric business, it's selling using a brand for the fabric business, maybe the persons who are involved in that fabric business, they may be knowing that, like, okay, this brand belongs to this company in this country, this brand belongs to this company in this country. So that's the concept, but that won't go with the famous marks that won't go with the marks which have the transporter reputation. So, I like to mention one case here. That's the first case of transporter reputation of well-known trademark. In sometime in 1970s or 80s, all the MNCs, they were restrained from coming to India and doing business. So, before 70s, the Whirlpool was doing its business, but there was trade restriction, and 80s they didn't have any business in India. In 90s, I think 95 or 93, maybe 92 was the time when the economic reform came and they started their business. But those 11, 12, maybe 15 years, they didn't use their brand, they didn't do any business in India. So, in those 15 years, there was another company, Indian company, who started using the Whirlpool trademark. They didn't have any objection when they were away from India, but when they re-entered in 92 or 93, they objected to it. They filed a suit saying that this person who was using that Whirlpool brand for the 15 years period time, he should be restrained from using, because he has copied it from the original Whirlpool.
The product is different.
No, the product was same, washing machine. So, the court said that was the first case in 95. The court decided that no, the other person cannot use this trademark, because the reputation of Whirlpool was so much that he couldn't have thought of that. Okay, he didn't actually, he has copied it from the main Whirlpool. The problem was that Whirlpool couldn't use their brand in India because of the trade restriction by government of India. It was not intentionally by the Whirlpool company. So, that was the first case where the court held the transporter reputation, even if the Whirlpool was not there, because there were some advertisements on Indian magazines having, say, if someone goes to the in aeroplane, and you will come across a lot of magazines where there are advertisements which are not being sold here in India also. So, people can think of a trade. Nowadays, it's quite easy without having any circulation in business. You can have you can know a brand which is not being used here in India, but in 95 the internet was not so much. So, the evidence which was submitted before the court was that there are some Indian magazines, there are some international magazines coming to India having the advertisements of Whirlpool washing machine. So, still the people in India, when even though the goods were not here, they were being exposed to the products of Whirlpool. So, that was the argument, and the court respected it. That was the first case, and after that there have been numerous cases where right now, because the tendency of adopting a name which is very famous outside India, people can think, because at the end of the day we have to respect, even if it is an Indian company or international company, you have to respect the intellectual property rights of the other parties. I think that's all I have. Yes. So, any questions? Because I think in the last session I missed some slides, and पीछे जाना है, ये बंद कर दीजिए आप, वो जो उसमें जाइए एक बार स्लाइड्स जो इसी में जो पेन ड्राइव में था, पेन ड्राइव खोल दीजिए। कितना टाइम हो गया? अच्छा, कोई और नेक्स्ट क्लास है अभी? कितने बजे?
Trademark agent, what are the career prospects?
What
What are the career prospects as trademark agent?
As a trademark agent, you can have your own firm. All the
I was going to ask a similar question. Please finish.
so either for practicing the trademark law, you should be either lawyer or trademark agent. Trademark agent, what will the trademark agent do? He will prosecute, he can file your application, he can file the application, trademark application. So there are only 3 persons who can file trademark application. One is lawyer, one is the trademark agent, or the client itself or the applicant itself. So trademark agent, he can file an application, he can advise on trademark law, he can do all those things which I told you. He can do all those things. He can do searching. He can advise actually on trademark law. So trademark law is you know how many firms we have in India on trademark law? Around 100 firms. Maybe Lex is the law.
Only 100 or?
Maybe more. Known, actually known, I'll say the 100. Yeah, lex means it's a Latin word. It means law. Orbis is taken from orbit, like all over the world. So yeah.
Examination for become a trademark agent?
Yes, there is exam. I think.
Notification just gave.
Yeah, notification is there.
Okay.
Yeah.
It has been kept?
Yeah. So I think the deadline to submit the fee is I think 11th September or something.
So how much they are charging by the way?
$1,000. You
And if I have a firm called Lexorbis,
Hmm.
then your company will be.
Then he will be the lawyer.
yes, yes. Well, have to because you know, law firms also, the lawyers also fight against each other. There's been recent, like in 2014, we have this case. One law firm name was Singh and Singh. Okay, the
Yeah,
Singh and Singh, Pratibha M. Singh's firm, and other law firm's name was Singh and Associates. Okay, so what happened that they were Singh and Singh is totally IP boutique firm, means they are only in intellectual property practice. There is another firm, Singh and Associates, who does the general law practice, means they have all the practice. They have infrastructure, they have real estate, they have intellectual property as well. But what was happening that most of the clients of Singh and Singh, IP clients, they were going to Singh and Associate thinking that it's the same company, same law firm, same lawyers. So Singh and Singh, they filed in suit against Singh and Associate. So lawyers were fighting against each other, saying that you were taking my clients. The court said, because at the end of the day, her name was Pratibha M. Singh, that's why Singh has come, and other person's name was Manoj K. Singh. So both have a valid reason why I am named my law firm. It's my surname. How can I stop you? How can judges also said that how can I stop someone from using his own name?
So what was the decision then?
Decision was that the judge said that to avoid confusion, the Manoj K. Singh firm, the Singh and Associate, they should write on their on the trading name Singh and Associates, a firm of Manoj K. Singh, so that it should be clear. Otherwise, you know, yeah. So that's the thing. I think that's fine. I think you have another class. So,
Sir, one more thing.
Yeah.
Regarding this trade, you said no international. What is actual benefit of that? Even without that, export of any product can be done in any other countries.
no, it can't be. The risk is, it can be done, but the risk is, suppose today you want to export, your manufacturing concern is here in India, you want to export Bata products. With the name, with this, I'm just taking this name, Bata. Bata shoe is being exported to say US, and there is another company who has registered or using Bata trademark for the shoe in US. As soon as you export, your export will reach in US. The court, first of all, if they go, if the original, the US company, they can file a suit against your importers there in US making your importer a party. So, if your importer is restrained from using the same trademark, then to whom will you export? Your importer was restrained from using a particular brand. He won't take anything from you. So, you need
That
to.
will be only in some cases, sir, this repetition of brand.
Yeah.
Whereas in popular brands, there won't be such problem. Like in case of Haldiram,
Yeah.
if it is the registration is only in India,
Hmm.
and if all those are exported to other countries.
That's why there is a problem with civil-based countries and what do you call? We have been facing a lot of problem. There is I shouldn't talk about that, but there is this brand who's very famous in India. People all over India, they know as far as that industry is concerned, that from what brand I'm talking about. But problem is there's a same brand who's using there's another company who's using the brand in Dubai, one is using in London. Because I didn't have registration, I sent him a legal notice that you have been infringing, you have copied from me. But the local lawyers in UAE and UK, they advised me that if you take any action against that party, the chances of success are very low. And I've been using that brand for the last 15 years in India, and it's very famous name in India. But I can't go and stop them from using the same Indian, like the employees who were working for me in my company. They went ahead and doing this show there in UK and Dubai, but I am not able to stop them because I didn't have any registration. Now I applied, but because of no registration, because these are some civil based countries where the common law rights are not available to you. So that's a problem.
In that case, every big entrepreneur or every big industry, they have to register all over,
Of
over all
course.
the countries.
Yes. And they go generally all
Even
those.
if they do not sell their products in that country, they have to have this registration.
If they
To
don't sell,
protect their trademark.
yeah, people do. Like we have in India, MNCs filing an application registering their brands in 1960s. They are yet to launch their product in India. So it's been 50 years now, because of course if someone has a problem with that trademark registration, with that brand in the market, they can come up and file a non-use cancellation. But that's a legal remedy they have, but not of course they can anyone can have a registration, and but that the problem is with the registration is also you have to use it in the market. Yes.
Haldiram now it has a very good name in India.
Hmm.
Suppose same name somebody copied in USA and selling by that brand.
Hmm.
Now Haldiram wanted to sell his product there in USA.
Hmm.
So you need to take permission from the fellow who copied his name from there and registered.
No, that's why in US you have a common law remedy. You can go and file an passing of suit against that party who's using the similar name. But the problem is that you have to establish that in US the people, Indian people, or the persons who are going to Haldiram shop in US, they are aware that the original Haldiram is in India. So all the products which have a quality product that belongs to the Haldiram here in India. So that the person who has copied it in US, he is not the right person. He has copied it from Indian Haldiram. And let's assume that if that company or person has been using Haldiram for say 20 years, and Haldiram India, they didn't go there, then the problem will arise. Because 20 years is a good number of time. So it's if you allowed that person for 20 years, now you can't go and say them this, until unless, like in the case of Whirlpool which I discussed, there was a trade restraining order from Government of India. Until unless the US government has such kind of problem with Indian government, that Indian business can't go there and have their business, I think the other person will be able to use its trademark if it is for 20 years.
After 20 years, suppose India, Alviram decided that I am going to go in US and sell my brands, whether it's necessary to have permission from that?
Whether it is necessary to
Have the permission from that?
Yes.
Having
Yes, absolutely. Then you will have to have you need to have permission. Otherwise, the same thing will happen because in US, in Europe, the damages of trademark infringement, damages of patent infringement are huge sum of money. You know, you may have to pay $500 million in punitive damages, something like this. So that's a problem. In Apple versus Samsung, the Samsung was asked to pay I think $500 million in as a damages, in a punitive damages. They willingly infringed someone else's rights.